Welcome back to the Reidel Law Firm Odyssey channel. Today we're going to chat about confidentiality provisions in franchise agreements. One of the key terms you need to be aware of. If you are looking to join a franchise system or you are thinking about franchising your concept and you got questions about these topics, reach out to us. The link is in the description. Schedule a call with me and let's chat about what you're doing, what you need, and see if we're a fit. So confidentiality provisions, let's do a little dive into that. Confidentiality provisions are essentially the mechanism for franchisors to protect the intellectual property of the franchise system. So this is going to be things like your recipes, your know-how, your secret sauce, your technical data, your workflows, things like that. So any type of systems developed that make your franchise system unique. Any type of operations or technical know-how or technical programs or recipes like I mentioned, all of that serves to make you special, right? Serves to make your concept, your franchise system unique, different, and profitable. So the issue is, how do we protect that? How do we make sure our competitors don't get it or misuse it? And some of our, maybe even insiders or folks inside our company, try to take it and compete with us, right? Unfairly, by stealing it. How do we do that? That is done through confidentiality provisions. And a typical confidentiality provision in a franchise agreement will state that you as a franchisee or an owner of a franchisee entity will be required to sign a non-disclosure agreement, to sign a confidentiality provision, and likely a non-compete, but we'll talk about non-competes later on another day. Along with signing that, typically your key employees will be required to sign it as well. General managers or unit managers or whatever, they will typically be required to sign that document as well, because usually they're going to be trained. They're probably going to have access to the operations manual, things like that. So they're going to be in positions where they may have the power to misuse it, unfortunately. So also one other important point is that your employees, even on the front line, who may not be key employees, but just day-to-day operational employees, running the man in the front desk or whatever, man in the kitchen, they also may be required to sign those agreements. And that's an important aspect of confidentiality provisions that has been popular lately. I think I've seen quite a bit, and we've had to add some of our franchisors because we've been in situations where franchisee employees will end up in a situation where they have the opportunity, and some in the past have taken that opportunity to misuse that intellectual property, that information that they have access to. So so that's an important issue that you need to be aware of. One of the things that franchisees sometimes forget is that they may be required to have those documents signed by their employees, and they don't do it. And then the risk of something going bad, your liability as a franchisee is very large. Could be major. So that's kind of in a nutshell for confidentiality provisions. It's something that's very it is ubiquitous in the franchise industry. Every agreement has them, and they're all very similar. But it is something to be aware of and to remember. It's easy to forget, and sometimes it's not so easy or clear for potential franchisees to really understand. Depending on the legalese that they use in there. So, if you need help understanding your franchise agreement or confidentiality provisions or liquidated damages or a whole host of key terms, reach out to Reidel Law Firm. We'd love to help you out, walk you through those terms, and figure out where you're at and if you need help and how we can help you, if so. Link is in the description where you can schedule a call with me. And until then, we'll see you next time.